What's up, everybody? Welcome into another episode of The Lawyer You Know. And we're going to be breaking down what should be the last pretrial hearing before Karen Read's jury selection starts on April 1st, a week from today. And they get into all sorts of issues here: third party culprit defense, attorney Yanetti's texts with Miss Read, some surprising and interesting things happening there. And we'll discuss what we thought was going to happen versus what actually happened and why that is and whether or not we agree with it and think it was the right decision, wrong decision. We'll get into all that, answer all your questions, I'm sure, as well. We'll talk about when the trial starts, what they know and what they don't know at this point. They do jury questionnaires. We are trucking towards starting this trial April 1st. No delays. Let's make it happen and let's get to the video now. Make sure you guys hit that like button. And if you're not subscribed, why? Hit that subscribe button if you haven't. So the first big ticket item and where we're going to spend most of our time in this hearing is going to be on the third party culprit defense. The judge has not made her ruling yet. But if we remember from the first trial, she said you can't mention an opening statement. You can't open on it. And she limited some of what the defense could do. But no real decision was made where she said, absolutely not, can't do X, Y, or Z. If you remember, the opening and the closing definitely mentioned that she was framed and that somebody else did this. So there was some kind of third-party culprit, but they're looking to name specifically three people. We'll hear from Brennan. We'll hear from Yanetti on this, and we'll try to determine what we think is going to happen with trial 2, because this is a big part of the defense's case, including the Bowden defense, the lack of investigation or horrible investigation or investigation that was not done the way it should be done. So let's take a listen first to Brennan's argument about why he thinks the defense should not be able to have the third party culprit argument.
They identified one person, Colin Albert. And in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant and national broadcasts, there's no evidence of that. There is no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022.
So interesting if you want to parse words, when John O'Keefe arrived there, but he never actually arrived inside, right? He means arrived outside, of course. And he's basically making the argument that there's no actual evidence that a third party did this. There's no actual evidence that Colin Albert, and he's going to take them in turn: Colin Albert, Brian Higgins, the three people the defense mentioned as the specific third parties they believe committed this crime that they want to discuss. They filed a motion. They proffered the evidence against them. He is going to repeat a lot of it here. Brennan arguing against it. Yanetti's going to repeat a lot of it on what evidence they believe is there. But the big combination and elephant in the room is the Bowden defense. The fact that the investigation was so bad. They didn't follow up leads. They didn't do everything they should have done in this investigation to where we could actually figure out what evidence there was against these third parties. And that's going to be a big part of Yanetti's argument, is that's the reason why. But even with that, we have a lot of evidence here that points to these three.
And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim that had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof.
Somebody asked about the speed. It's only 1.25. It's not even 1.5. Hank Brennan speaks quickly. And I want to get to a big chunk of Brennan's argument and a big chunk of Yanetti's argument. And as you know, you can always slow it down on your side. I will do my best to repeat the important parts and make sure nothing gets missed. I feel like this light is shining right in my eyes.
Actual proof, fact, that this actually happened, then there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen. So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud,
And you guys tell me, as you hear him recitate and repeat the facts that the defense has proffered against these three potential third-party culprits, what does it make you think? Does it make you think there's something there? Is there more there? Is it more likely them than Karen Reed? Those aren't necessarily the standards, but how a jury looks at it is it possible that it was actually them? Is it a reasonable doubt that they maybe could have done it if there was more of an investigation? Do you think it's a total, throwing crap against the wall to see what sticks from the defense? What do you think when you hear the explanation of the proffered evidence against the potential third-party culprits?
Tough relationship. I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed. And during conversations, at least they relayed that there was some claims about a drug issue. And according, not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin Albert and John O'Keefe. We know that
this is his recitation of the facts, right? But if other people have a different opinion that there is animosity, then that would be proffered evidence from the defense of something they would be able to present as a third-party culprit defense. But Brennan is basically testifying that this stuff doesn't exist and there's no evidence. It's very different.
That there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seems to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, I think they did this to introduce a trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles, subsequently, because he may have done a video that some youths would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't.
So again, you can't say, hey, we think this guy's a third-party culprit because he's a bad guy. He's a jerk. People don't like him. You can't generally do that. But sometimes a propensity for violence, definitely if there's some rub in the relationship between the defendant and the victim, or I should say the third-party culprit and the victim, that can come in. If there's been any animosity in the past, if there's been a physical altercation in the past, that could come in. Yanetti is going to cite a bunch of cases that would stand for the proposition of bringing in this type of evidence. Brennan's going to cite cases that stand in opposition of bringing in a lot of the evidence, and that's where Judge Cannone is going to have to make her final decision. Cassie said, I watched a bit of it this morning. Did the state basically refuse to even look into another person, feud or not? Shouldn't they entertain more people? Yes, they should follow the evidence and do an investigation into anybody that could have possibly committed this crime. Now, in lots of cases, people could say, why didn't you interview this person? Why didn't you interview the boogeyman? Why didn't you interview this bad guy that committed these crimes? You should have investigated every single person. The state will say, we went where the evidence pointed us. The cops will say, we went where the evidence pointed us. The fact that they didn't investigate any of these third-party culprits is like number 20 on the horrible list of things they didn't do in this investigation. They screwed this investigation up from the jump 1,000 different ways. This is just one of the ways they screwed up the investigation. Evidence collection, tracking, chain of custody, even going and looking in the house. They didn't have to specifically point their finger at any individual person, but was there any evidence in the house? And, we can talk about the tail light. We can talk about the vehicle going in and out. We can talk about the videos, the surveillance camera, where people were that night, cell phones. Did you get accurate records? Did you not? Did you screenshot versus a download? All sorts of issues that happened in this case during this investigation. This is just one of them. Motion to dismiss. My StreamYard is like freezing here. I don't know. Am I frozen? Let me know in the chat if I'm frozen because my StreamYard is freezing. John, I can't hide the comment. Can you bring this comment down? Okay, there we go. Motion to dismiss has officially been denied. I don't have it. If somebody wants to email that to me, maybe we can take a look at that at the end as well. I know. Thank you, everybody, for telling me I'm not frozen. It's just a StreamYard issue, I guess. Okay, now it's working again. So the motion to dismiss has been officially denied. No surprise there. That's what we expected. But there are some surprises coming in this hearing. So let's get back to the argument.
They have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. No one is a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all, no root. They went as far to say he was investigated by BP.
So some of that was allowed in the first trial. A lot of it with Colin Albert was allowed in with the knuckles and the videos and things like that. Some of it was able to be discussed. Some of it was not. I expect her to parse it out again, allow some, but not all of it.
For violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically.
And he's right. You can't make general bad character evidence accusations, but if you can connect it to a third-party defense, there are courts that will allow certain information to come in. EB says, why an ATF agent wiped his phone off with FBI equipment, destroyed it one day before the court order? To me, that's important. I don't remember if that was asked to any of the jurors that, gave interviews, but that's the type of stuff to me where I was like, what? Like that doesn't add up to me. Why would you do that? The great thing about the truth is, no matter how often it's tested, it remains the same. Brennan is acting like a defense attorney, not a prosecutor. So I've seen some comments, right, on the dangerous world that is X/Twitter, that some of his clients might not be so happy about what he did with the attorney-client communication, how he's acting with what a defendant's rights are before trial, how he's handling certain discoveries, certain publicity and interviews and things like that. And it's like, I don't know what his clients are going to think. I don't know what his clients are going to do, but I think he's a good lawyer overall. I think he does a good job making his arguments, litigating this case, handling discovery. People hate him. That's normal. People are going to hate people on the other side. Lawyers understand that. They know it's coming. But I will say, I wonder what his criminal defense buddies think and what they're going to talk to him about after this case. Like if this was my buddy, I'd like to sit him down for some coffee, or maybe we go play a round of golf. And I'm like, bro, what was this? And ask him about a few of the things made. It would be a very interesting conversation.
He's a bad character. Brian Albert is a two-time recipient of the George Hanna Award, has many, many medals of honor from the Boston Police Department, but that is not the issue. They suggest that he was involved. So they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is no association between the two. They say he's present at the scene of death. By all evidence, Mr. O'Keefe died feet from the street near the flagpole in front of 34 Fairview. So that's
another argument that he makes that is just, to me, not a good argument, right? It's just not a good argument to say, well, he died outside. He never went inside. Therefore, none of them were at the scene of the crime. It's like, well, technically, to get in the house, every single one of them had to walk by the scene of the crime, right? Every one of them had to walk by a body in the snow. If that's their evidence that that's where his body was, so many of them, they said they didn't see it, but they still stepped foot right there to be in the vicinity of what the Commonwealth is alleging is the crime scene. So another bad argument, even if you're going to say he didn't go inside, to me, that is nowhere near enough to strike these people as third-party culprits. It would be like saying, I didn't commit this crime because I was nowhere there. I've never been to 34 Fairview, right? That's what he's acting like, is, oh, none of them were even at the crime scene because they were inside the house. It's like, not buying that one. What if Karen Reed won't be allowed to bring a third-party culprit defense focus only on reasonable doubt? Well, I think she'll be able to bring the Bowden defense no matter what, which is the bad investigation. And I will tell you what I think is going to happen with the third-party culprit defense, and I'm confident in what I think is going to happen. I've been wrong before, no guarantees, but I'll tell you why, and then you can take my reasoning why and what I think is going to happen, and you can test it yourself to see whether you agree or disagree.
That's a little bit broad. He wasn't present at the scene of the death. He wasn't there. That happened out front on the front yard near the flagpole, about 70 feet from his house. The body was found feet from his front door, arguably, 70 feet, 75 feet. He admits to being home. He doesn't have to admit he was home. Now, here is another claim without any evidence whatsoever. The defense states emphatically, computer forensic data overwhelmingly establishes O'Keefe entered Albert's house. I haven't seen that evidence. Based on what? So if they're going to make
that makes me think, is there more? Is there something else? Is it the phone data? Is it the stairs, going up flights of stairs? We know how the Commonwealth's going to combat that. It could be hills, whatever. Is the defense going to have stronger testimony this time that actually is stairs? Or is there something more? Is there more forensic evidence that John O'Keefe entered the house? I don't know. Strains credulity. Peter, if you were defending this case, what strategy would you go for? Would you go heavy on third party, or would you just focus on the terrible case? I think the defense went too hard on third party. Yeah, so I've talked about this a ton. I would go heavy on reasonable doubt in the investigation. That would be 99% of my case. And I might say, we believe something happened in the house with one of those people, but we can't prove it because of how bad the investigation was. I may, just to give them somewhere else to point the finger, if the jury's like, well, if it wasn't Karen Reed, who could it have been? A lot of jurors think that. I wouldn't go as heavy into the third party culprit defense, but these defense attorneys know what they're doing. They're skilled. They're experienced. They did a really good job in the first trial. They're doing a really good job litigating the second trial. So, that's just one person's opinion of how I would handle it a little bit differently. Christy, as Brennan, what would a lawyer gain in taking a special prosecutor role in this kind of case? He already had notoriety from the Bulger case. So if he wins, he will be able to tout that as, I went and won maybe one of the most high profile criminal trials of the year, maybe of the decade. He went and won a case where they got a hung jury before. He had to go in there and help this prosecutor's office. So now he got such a great relationship with this prosecutor's office that if you get arrested or indicted in this town, maybe you want to call Hank Brennan. He does such a good job. He knows this prosecutor's office better than they know themselves. He's better than any of these prosecutors. So why not have that guy represent you? A lot of lawyers sell that, right? Former state prosecutor, former federal prosecutor, former judge. I know how the inner workings work. I think it's definitely something you can sell as a lawyer if he goes and wins this case. Bettero called it draconian and Orwellian. Yes, we will get to the part where I'm sure he was talking about. Motion dismissed just dropped. Can you cover it? Yes, send it to me. If you guys send it to me, I'll take a look at it.
Offer proof to the court, and they're going to make claims to substantiate this theory. they have to have proof of it. And in their motion, I see no proof whatsoever that overwhelmingly establishes John O'Keefe went into the Albert house. In fact, what we see is the opposite. In the past trial, numerous people were called. Every single person that was asked stated they did not see John O'Keefe enter that home. Every single person. Now, whether you believe it or not is irrelevant. What's relevant is there's nothing to the opposite. There's an absence of evidence to the opposite. In fact, the phone data and the Waze data and the GPS and all the data puts John O'Keefe at the front yard, not in the house. So if they're asking the court to make a finding of substantial link and substantial proof that John O'Keefe was in the house, they have to actually give you the facts and the science and the data to support that. And I don't expect that will happen. They add that there was going to be expert testimony that the scratch on John O'Keefe's arm was from an animal or a large dog, and because Brian Albert had a dog in the house, there was some type of inference. Dr. Russell has already testified at the Lanigan hearing that she's not saying that those bite marks were from Chloe. Although it's not been decided by the court, Dr. Crosby has done molds to show that the teeth comparison is totally an opposite. And so even the defense is not saying, as I see from the disclosures, that Chloe bit John O'Keefe. Their version, which we don't agree with, is that a large animal or a dog caused these wounds. They don't say where, they don't say when, they don't say how. And so that is not a link so that Brian Albert becomes a third-party culprit. Finally, in a way to try to create some type of traction against Brian Albert, they associate him with Brian Higgins because they spent the day together, because Brian Higgins, according to them, was rebuffed because of phone calls at night. All of these general claims with no fact predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There is not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there was no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night. Finally, the defense turns to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed went to Mr. Higgins' house. And so there was some interest that would appear from the text messages between the two, mutual. At best, there's a plethora of...
Listen, however you want to characterize their relationship, you can't say that two guys liking the same girl could never be a motive to get in a fight, right? Whether anybody intended to kill anybody or whatever, like that could definitely be a motive for a fight, right? Between two guys. I would say that that's like the age-old number one reason, right? Money or love. And so to act like, oh, there's no way that's any motive, it was mutual. It's like, okay, if you say so. Froggy Girl says, if they can't use third-party culprit, does that go against fair trial? Also, is that just another notch on the appeal? I mean, it's an argument. It'll be an appellate argument. I don't think it would be their strongest one. Jonathan Dean, if she can bring the Bowden defense, then shouldn't she be able to present Birchmore case because it's the same district attorney's office? I don't know. No, not automatically, I will say. Maybe, and she can still try to make that argument. I don't expect much of that case to come in. But they'll still be able to do the Bowden defense because guess what? They screwed up so bad in this case, they can use this specific case. Now, if they get to impeach, depending on what some of the cops say, if they can impeach them with things that happened in the Birchmore case, that's how I would try to bring it in. Like, you guys always do this type of stuff, right? This isn't the first time you've screwed up and not found a cop to have committed a crime and try to pin it on somebody else or tell some other story and say that it was just, she did this to herself. Wouldn't be the first time, would it? If they say no, then maybe you can get into some of this stuff. If the judge, it all depends on the judge's discretion and what they allow. Which another decision she made today depends on the same discretion. Siobhan, he knows the investigation was trash, right? He's just doing his job because he believes in justice and this is all he got, right? Lawn, house. I mean, I can't imagine that somebody like Hank Brennan thinks this was a good investigation. I think he's basically admitted it was a bad investigation. He has admittedly thrown Proctor under the bus, from my recollection.
Text messages where Ms. Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. And one, she says, I was basically begging him to come over. Do you like me? Come over to my house. There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting.
I feel like it could be. I'm not saying it is, right? But maybe you look into that if you're the cops and you find out about that. He was there, he was drinking, he was flirting with his girlfriend. Maybe he got mad. Maybe they got in a fight. Maybe John O'Keefe found out. This is nowhere near enough evidence to convict Brian Higgins of anything, right? Way too many holes, way too much reasonable doubt. That's not what a third-party culprit defense is. And that goes to the Bowden argument and discussion, that no investigation was done.
That night, he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship. Is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins.
And he's right. And that's what the Commonwealth then would present to show that's not actually correct. And that's what he does a lot with his arguments. He'll like make an argument to the judge, like, yeah, but that's your job to do in cross or in response. He also argues that it shouldn't be allowed, the third-party culprit defense in conjunction with Bowden as well. He talks about how I can't remember if it's Higgins or Albert has like a history of sucker punching cops and stuff. I mean, he goes into a lot of the details that they get into in the defense's motion. But let's jump to Yanetti now. He says they're separate issues, evidence of a third party. Each had motive and opportunity to harm John O'Keefe. The Bowden defense is something separate. So let's listen to how he describes what they want to do and why. And I also think it's interesting he mentions the fact that they have the witnesses on the witness list that are going to be able to help with this. There will be evidence in the form of testimony.
An opportunity to harm John O'Keefe. The investigators in this case had evidence that pointed to Brian Albert. Brian Albert is a violent man. He was not only a boxer who punched people in the ring, he was also a violent drunk who sucker punched other police officers. Those police officers are on our witness list. He's been investigated by the.
I'm going to have to skip a bunch of pauses. The feed went in and out, but all of this can be found in their motion as well. But he is known for sucker punching cops. And guess what? We don't have to take Yanetti's word for it. They have those cops on their witness list.
But it exists. It's a live issue at trial. At the time John O'Keefe entered that house, an intoxicated Brian Albert was inside. He had been drinking day and night for hours at a time, and he was liquored up. He testified to that. He was at the hillside when he had his first drink in the afternoon, and he testified under oath he was drinking consistently.
Yeah, great point, Western Mass Attorney. Great point. It's like
the entire rest of the day and night. The Commonwealth says that every single person didn't see him in the house. Those same witnesses that the Commonwealth points to, every single one of them also did not see him on the front yard where Mr. Brennan claims that he was at the relevant time period. That day and night, Brian Albert was attached at the hip to his close friend, Brian Higgins. This was the night that after having carried on a flirtation with Ms. Reed while she was dating Mr. O'Keefe, Brian Higgins was confronted with Ms. Reed and Mr. O'Keefe together. In the words of one eyewitness, Ms. Reed and Mr. O'Keefe appeared to be lovey-dovey that night. Higgins had expressed his interest, but it went nowhere. And it went nowhere because prior to January 28th of 2022, Ms. Reed had rebuffed him, essentially ghosted him. She stopped returning his messages. Brian Higgins was liquored up that night as well. They're both very large men. The court saw them on the video. Friends who drank the entire day and night, and they were waiting in the house for Mr. O'Keefe to arrive. Mr. O'Keefe ended up dead because he went to Brian Albert's house. After Brian Higgins left, Brian Albert maintained contact with him. At 2:22 in the morning, the two of them were exchanging phone calls to check in with each other just a couple of hours after Mr. O'Keefe was mortally attacked. Mr. O'Keefe had dog bites and or scratches on his arm consistent with a dog or an animal attack. Brian Albert had a large German Shepherd who had attacked and injured somebody in the past.
This is him laying out what the evidence is that connects these third-party culprits that he wants to put before the jury for the jury to consider. Now, you have to balance. You can't just confuse the jury or trick the jury with, trying to pull all this stuff that's irrelevant and connect these people that have nothing to do with it, right? And that's what the Commonwealth's arguing. That's what they're doing here. They're just coming up with crap that doesn't even matter. It's not relevant. It doesn't connect these people to the crime at all. The defense is like, oh no, it does. And specifically these three people, and the judge has to decide how much, if any of this, is going to come in. Drew said, I've been waiting to catch you live to ask you, since Proctor is now officially terminated, what if he flees the subpoena like the girlfriend in YNW Melly first case? How devastating is that for either or the Commonwealth or Karen Reed team? I think it would be more devastating potentially for Karen Reed's team, but I think if he tries to flee, they're going to go find him and they're going to handcuff him and bring him in. That's what I think would happen. And I think the defense would say, let's pause this trial, or we've got to dismiss the case now because this happened. They're all colluding together for him to disappear. I think we would have a whole trial within a trial if he tried to flee this subpoena, and the Karen Reed's team would do everything they can to get Proctor. And if they couldn't get him and they continued on, they'd be able to bring in everything and then say, and he fled his subpoena and there's a warrant out for his arrest because he refuses to show up, and they would use that then against them. Courtney, is there enough here for an appeal? Sure, there's going to be enough for an appeal. Will it be a successful appeal? I don't know. Let's wait till after the second trial and we can talk about what comes out and whether or not that is going to be enough for an appeal. Does the Commonwealth have to retry Karen within a year of the mistrial? What happens if it doesn't start before the 1st of July? It would be potentially, I'd have to look again at the rules in Massachusetts, but it would potentially be dismissed and it would be a lack of speedy trial, and they would violate her speedy trial rights and they can't bring the charge again. That's how most jurisdictions work within the time period for a retrial. Kim said, I usually agree with you, but you think Hank Brennan is a good lawyer when he's blatantly lied in open court. So I think you can make argument. I think he's absolutely, I don't know if I will say like blatantly lied in open court. He's absolutely misstated facts. I guess we could say, like when he said that this was given to him by the defense and not the feds, I don't think that was a lie. I think that was a mistake. And when he makes these arguments that are semantic arguments or cherry picking certain things, I think there is some truth in what he is saying and some misrepresentations. People can say that about a lot of lawyers. And I didn't say he's the most ethical lawyer. I didn't say he's a lawyer that I would choose. I didn't say I think he's the best lawyer in the world, but I think he is objectively a good lawyer on the spectrum of lawyers, especially when compared to the old prosecution team. I don't think that he is just a flat out liar in court, just like I don't think Jackson is a flat out liar in court, or any of the defense team that's been accused of certain things that the judge has found as misrepresented facts. I think a lot of lawyers that make arguments in the best light to them, believe what they say, sometimes can twist words and scenarios and facts in a way to make them fit to their argument. I think that can be said about a lot of lawyers as well. I'm not saying he's perfect. I'm not saying he's the greatest lawyer in the world. I'm not saying he's never lied. I'm just saying objectively on a spectrum, from my assessment, which can be very different from yours, and that's totally fine. And you can let me know. You let me know you disagree with me. That's just my assessment of his lawyering skill in litigating a criminal case.
It all fits. The Commonwealth utterly failed to investigate Brian Albert as a potential suspect. And I'm sure the court remembers the words in a text message of now ex-trooper Michael Proctor, the lead investigator who's now been fired as a result, in part, of being biased in this investigation. I would point out also that when Mr. O'Keefe was in the house, both Brian Albert and Brian Higginson were unaccounted for, according to the testimony. With regard to Michael Proctor's words, he was asked specifically if the homeowner would catch any grief for having a deceased person on his front yard, and Michael Albert was a first responder. He chose to ignore his duty to help somebody in need and instead stayed in his bedroom. And Brian Albert's dog, the family dog, a member of the family for 7 years, Brian Albert got rid of the dog, shipped it to another state, only after it was made known in court that the defense was alleging that the dog had been involved in the attack on John O'Keefe. We showed photos of John O'Keefe's arm in a public hearing where it was clear to any unbiased observer that Mr. O'Keefe suffered those particular wounds from a dog or animal attack. Brian Albert responds to that allegation by essentially divorcing his family from their beloved dog, whom they had for 7 years and certainly considered to be a member of the family. In the aftermath of John O'Keefe's death, Brian Albert went so far as to send that family member to another state. That's enough evidence to point to Brian Albert as a potential third-party culprit in this case. with Mr. O'Keefe. Ms. Reed and Mr. O'Keefe are affectionate with each other that night, and Higgins is there to see it, as is Brian Albert. There's evidence that Mr. Higgins wants Mr. O'Keefe to come to the Alberts' house that night. In fact, he appears fixated on making sure that Mr. O'Keefe went there. In the waterfall video, Your Honor, you will see that Higgins motions to Mr. O'Keefe when they're leaving. And Higgins even texts him directly after that to make sure that he was coming. Then Higgins goes to the Albert home. John O'Keefe goes inside. Higgins is there waiting for him, with both the motive and now the opportunity to hurt John O'Keefe. Like Brian Albert, there's evidence of his consciousness. He's lied about that.
My bad. Just realized I was muted. In my opinion, he's proving, one, his case is weak against Karen Reed. Two, he is clearly here to defend the McAlberts. And three, he's desperate to get the judge to act as the fact finder and keep the jury from hearing the truth. A lot of lawyers do number three all the time, in the form of motions in limine, in the form of using the rules of evidence. That happens all the time. People can be accused of that. And the lawyers that are doing it, myself included, sometimes if I'm trying to get facts out that I don't think are reliable, I don't think are relevant, I don't think are probative, I think are purely prejudicial, you could make that argument anytime a lawyer wants to keep a fact out of the trial. But I do agree that the case is weak. I think he is trying to bolster his case with a ton of experts and a ton of witnesses just to be like, look at everything we've showed you. I've got a lot of thoughts on how he's putting this trial together. That's going to be very different than Lally. The thing that keeps coming in my head, how is he going to deal with the investigation? How is he going to deal with that? Because we found out now how he's going to deal with ARCA. He's going to try to make them look like defense witnesses, not federal, not hired by the federal government. He's got his own expert that's going to be better than Trooper Paul. I just have to assume any expert in the world will be better than Trooper Paul. So he's going to deal with the accident reconstructionist. He has his own evidence. That's what I expected the Commonwealth to do in the first trial. But I really have no clue how he's going to deal with the investigation. I've racked my brain. I try to see it from both sides. I try to see, how would I prosecute this case? I don't know what you do with that evidence.
The jury in this trial should be entitled to consider the answer to that question. And of course, the police never investigated who he was calling or what he said or who was calling him. Then he goes home and he still stays up. And at 2:22 in the morning, he's speaking by phone with Brian Albert. And he claims that they didn't, but the phone records don't lie. And this notion that these two men are somehow able to butt dial and butt answer each other is just ridiculous. And there's more consciousness of guilt evidence with regard to Higgins. When he realizes that investigators might be interested in the contents of his phone to see what evidence might be on it, he demonstrates consciousness of guilt by getting rid of his SIM card and the phone itself. And how he got rid of it was extraordinary and demonstrates just how badly he wanted to keep that information out of the hands of investigators. He admitted to breaking the SIM card into and making a special trip to a military base to put this tiny object the size of about a thumbnail.
I mean, imagine if a criminal defendant did that. Imagine if Karen Reed did that, the heyday prosecutors would have with it, right? The sanctions that would be coming. And I know he's not a criminal defendant, but in a third-party corporate defense, that to me is...
It wasn't enough to throw it in a waste paper basket or a trash bin outside the local Dunkin' Donuts. Instead, he went through security at a military base and secretly tossed this tiny broken SIM card into a dumpster. He made sure that investigators would never know what's on his phone, and he admitted to that at the first trial. And of course, the investigators in this case, including the lead investigator, former Trooper Michael Proctor, never showed any interest in Higgins' phone. Higgins nonetheless accomplished his goal of keeping the contents of the phone out of the hands of the defense in this case. That's powerful evidence of motive, intent, opportunity, and consciousness of guilt to Brian Higgins. As Mr. Brennan acknowledges, all doubt should be resolved in favor of the admission of third-party culprit evidence, linking him to the harm caused to John O'Keefe. And finally, Colin Albert is a potential suspect. He had been in a feud with John O'Keefe. He'd thrown beer cans in his bushes, told him to F off. We have a good faith basis to claim that. This is the same Colin Albert who testified under oath he had never been in a fight in his life, yet there are videos of him clearly desperate to beat up others. The same Colin Albert who had scraped up knuckles just a few weeks after John O'Keefe's death. Those knuckles look consistent with an attack on somebody. The photographs that Mr. Brennan references that were allegedly before that photo had no metadata. We can't confirm when those were taken. Mr. Brennan wants us to just accept the testimony that they were taken before the scraped up knuckles photo.
Yeah, because Brennan said so, right? It's how he argues. He argues his arguments as facts, as if he's testifying. Will's mom said the new Trooper Paul witness is Trooper Paul's boss, who taught Trooper Paul everything he knows. So I've heard reports of this, and this will be interesting. I know, the internet's going to say, well, obviously he's an idiot too. If he taught Trooper Paul everything, fine. But the more interesting part to me is that's even better when it comes to, well, here's what Trooper Paul said. What do you think about that? Do you agree with it? Do you disagree with it? Didn't you teach him? So it almost makes him kind of adopt part of Trooper Paul's accident reconstruction. So that'll be interesting to me as well, to see how different it is. And if it's different, how he deals with whatever his connection is to Trooper Paul. And even if he's not, you could say, so then, while the expert's on the stand, I would say, so then, Mr. Expert, do you believe that it happened by just hitting the side of the arm and causing him to pirouette and, X, Y, and Z and repeat Trooper Paul's testimony? Do you think that's what happened? Is that your opinion? No, that's not my opinion. Okay, is the opinion that blah, 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 blah. And you read the whole Trooper Paul opinion, get him to smash it, and then let everybody know that's MSP Trooper Paul's opinion.
We don't buy it. We don't think the jury will buy it. When John O'Keefe was found, he had two black eyes looking like he had been punched in the face. Colin Albert was at his uncle's house with both his uncle and Brian Higgins, disliking Mr. O'Keefe for a different reason, but disliking him nonetheless. And it's suspicious that Colin Albert's name was purposefully omitted out of the police reports. There was no indication in any police report provided to the defense in the first few months of this investigation that Colin Albert was anywhere close to 34 Fairview, his uncle's house, on January 29th. In fact, there's no indication in those police reports that Colin Albert even existed. Initially, we didn't even.
So somebody said my audio is cutting in and out. I'm not sure why. I will try to fix that. Hopefully the court audio is okay. I know it's not the best audio in the long crime stream, but I think if you refresh your stream, yeah, that'll help, because Kelsey's saying no audio issues. So if you refresh the stream, I think the audio issues you're having with me is, I see people saying not just the court. So try to refresh and see if that fixes. So my bad.
Know who he was. But we found out when we sent a letter to Mr. Lowry, while the case was still pending before a grand jury, notifying the Commonwealth that Colin Albert should be called as a witness before the grand jury. It was only after we sent that letter, notifying the prosecution that we were on to Colin Albert, that testimony was elicited that Colin Albert was indeed at 34 Fairview that night. The defense caused this to be revealed, not any investigator of this case. And there's obviously an inference that his name was kept out of the police reports to protect him. The same way Brian Albert is the only person listed in the initial report whose first name is not even spelled out. He's just listed as B. Albert with an incorrect address. There appeared to be a conscious effort of these investigations to hide third-party culprits from the defense. All of these men, Brian Albert, Brian Higgins, Colin Albert, were present at 34 Fairview the night that John O'Keefe was killed, and each had a motive, intent, and opportunity to cause him harm. Now, there are many cases, Your Honor, I know the court is aware of this, endorsing the admission of third-party culprit evidence. Almost all of them allow in a third-party culprit defense, despite a lack of evidence that the third-party culprit in those cases was actually at the scene of the crime at the relevant time. The first case cited by the prosecution, Commonwealth versus Conkey, Middlesex County case, I remember it from the 90s. It was retried in the early 2000s. In that case, the person was murdered inside a home, just like this case. Unlike this case, however, the defense could not place the third-party culprit at the home when the murder was committed. He lived down the street, and that was enough. Here we have hard evidence, irrefutable evidence, that the three potential third-party culprits were present exactly when the murder was committed. And it's notable that the defense in Conkey, in that second retrial, after the first trial was.
I also love when a lawyer cites a case he handled, which Yanetti does here, because then they really know it. And it seems like a much worse case, a much less good third-party culprit argument, and yet it was allowed there. So it should definitely be allowed here, is what he's arguing. To me, that's a pretty great argument for a defense lawyer to be able to make.
Conviction was reversed. The defense was allowed by the trial judge to present a third-party culprit defense, and it wasn't controversial. But the conviction was nonetheless overturned, the second conviction, on appeal, because the trial judge didn't let the defense go far enough in presenting that defense. The SJC ruled that in addition to presenting evidence of motive, intent, and opportunity, The defense in that case should have been allowed to introduce past sexual assaults of the third-party culprit, including one that took place 7 years before the murder. It was reversible error not to permit a full third-party culprit defense, including prior bad acts of the third-party culprit. And I will ask the court to consider Commonwealth versus Finney, a case that I'm very well familiar, as I previously mentioned. I brought that motion for new trial. I argued before the Supreme Judicial Court, and I tried for retrial of that case, so I know it well. The SJC affirmed Judge Ball's allowance of the motion for new trial in that case, ruling that it was ineffective assistance of counsel that the attorney did not raise a third-party culprit defense. The case law makes clear, as Mr. Brennan again acknowledges, that this defense is a time-honored method of defending against a criminal charge. The defense should be given wide latitude to present relevant evidence that somebody else committed a crime. But the main issue in Finney was whether the defense could introduce hearsay to support an already admissible third-party culprit defense. It's sort of like Conkey, where it's just assumed, yes, of course you can present a third-party culprit defense. But in Conkey, can you introduce unrelated sexual assaults from 7 years before? The answer was yes. And in Finney, of course you.
So much more prejudicial, much more damning, much worse for your character, but that was all allowed. Paula said, Peter, I've been waiting to ask after the hearing where Bev scolded Alan in open court and talked about candor. Does this mean that that is on his record now? And if so, can he challenge that? So it's nothing officially on his record. She didn't make an order, but if a lawyer wants to get the transcript of that hearing or pull the YouTube video, they can quote exactly what the judge said about him. And it's hard to fight when a judge says something about you on the record in open court, right? It's not like an order that you can appeal. If she would have sanctioned him or something like that, then he could have appealed it. It didn't go that way. Kathy said, are you still doing quarterly Zoom calls for the members? I was thinking about upgrading. Yes, we are. And we've got some fun stuff planned for this upcoming quarter. We really get to dig in. It's a smaller group. It's really fun. We'll talk more about it on members only video, maybe. I don't want to take a lot of time here talking about it. But Yanetti's rolling in this argument. When you give examples of even more was let in, and even worst case it was let in, it should definitely be let in here.
You can present a third-party culprit defense, but can you also introduce hearsay to support that defense? It was a given. In fact, it was reversible error that the third-party culprit defense was not brought the first time around. Mr. Brennan talks about, well, you can't do this if it prejudices the Commonwealth. That's crazy. Every single time you introduce a third-party culprit defense, you are prejudicing the Commonwealth by definition. You're not going along with their theory of the case. Mr. Brennan's grieved that we would deign to present this defense. And I would note, Judge, there's, I believe, a certain amount of gaslighting going on here in that on one side of his mouth, he talks about he wants Ms. Reed to have a fair trial. But we've spent weeks where he's just trying to knock out all our evidence, just limit everything. He's, I believe, acting more like a defense attorney than a prosecutor in that regard. But regardless.
That's where a lot of the internet got it, right? And he says, he's taken some serious shots saying he's acting like more of a defense attorney than a prosecutor, but he's acting like, no, I don't want to, I'm not trying to get into any arguments. I love Yanetti's style. He's got a nice guy style, a guy that it's hard to be like Jackson. He is tough. He's harsh. It's like you want to battle. Jackson's the type of guy you can get in a fight with, right? Yanetti, you look like a jerk if you fight with him. That's what I kind of feel like. I really like his demeanor. But he says it, and he's like, on one side of his mouth, he says he wants a fair trial, but everything he's doing seems like he wants an unfair trial. That's gaslighting. And we said it in the beginning. We're like, great. I hope he's being honest when Brennan says, yes, he wants her to have a fair trial. Then when you're trying to get rid of every defense that a criminal defendant is entitled to, doesn't really feel like you want it to be a fair trial.
In terms of these cases, Mr. Brennan said that they all have third-party culprits who have relationships to the alleged victim and or relationships to the scene of the crime. Faye did not. In Faye, my client was the next door neighbor. My client signed a confession to the murder. The third-party culprit lived several houses away within the same city, but not close, not next door. There was no relationship other than he made statements about how the victim probably deserved what she got. She wasn't the goody two-shoes, but there was no, that she was made up to be. But there was no witness that put the two of them together in any way other than those hearsay statements. Nobody put him at the scene of the crime. The SJC.
This is a good point Sleuthy brought up. People forget that both Yanetti and Jackson were previously prosecutors. yeah, I don't know Yanetti's career as much as Jackson's, but like high profile, big time prosecutor, like almost felt like a lifetime prosecutor. He did so much in the prosecutor's office. That's very common for criminal defense attorneys to be former prosecutors. So a lot of us know exactly what it's like working in those offices. And once you work in that office, you have a lot of friends in that office and a lot of friends that become judges that were former prosecutors. So it's not like everybody is, it's the dark side and the light side and they never cross over. It's very uncommon. Like a lot of criminal defense attorneys are former prosecutors.
The rule, even hearsay should be admissible to support that third-party culprit defense. The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Brian Albert, Brian Higgins, and Colin Albert had. That's the nuts and bolts of a third-party culprit defense. So that's the first issue, presenting evidence of a third-party culprit defense. The second issue is whether we can argue in closing that a third-party culprit is responsible for John O'Keefe's death. That's an issue I suggest that the court does not need to decide now in advance of trial.
And I think the judge is going to agree with that. So I don't think she's going to decide about closing yet. So that's basically the end. He does talk about the Bowden defense, and he talks about how, Proctor being fired is important because it says that he showed apparent bias in his investigation, told his friends he has no interest in investigating cops, basically. So he does get into that. But here's what I think Judge Cannone is going to do with the third-party culprit defense. I think she's going to do exactly what she did in trial one. I think she's going to say, you can't open on it. I'll decide whether you can close on it, and we'll see how the evidence comes into trial. She's not going to say yes. She's not going to flat out say no. And it's just going to be kind of a witness by witness, case by case thing. I know Yanetti's not doing the opening, for the defense to push that line and talk about it in opening at least a little bit, or infer that something else happened. And I expect Judge Cannone to allow a little bit of it. Maybe she won't let him name Brian Albert, Brian Higgins, Colin Albert, but I do think she is going to allow them to get into Karen Reed was framed. She didn't do this. She's actually innocent, if that's the route they want to go. I expect more objections from Brennan than we got from Lally, but I do think they are really going to push the envelope with that. Brennan gets back up, focuses on, again, that there's evidence that John O'Keefe didn't go into the house. Defense wants to tell the jury, some story diverting their attention because there's no actual evidence of third-party culpability. And then he said what I took issue with the most. And again, just because I say he's good at being a lawyer does not mean that I don't think he does anything slimy. It doesn't mean I don't think he does anything shady. Like, there are lawyers that I think do a good job and present well that I still think do things that are underhanded. This is something I think was underhanded. This is something I think you got to know better than to make this argument. Let's listen to it for a second, and then I'll repeat it if you can't hear it, and we'll discuss why it's troubling.
The third-party culprit, the defendant should be entitled to use it. In this case, there is not. There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. Certainly the defense can infer certain facts, like getting rid of the SIM card in a way they want. And I don't begrudge that at all. There's different interpretations of it. I understand that. This was heavily considered in the federal investigation. And after that absolute thorough investigation, there were no charges.
Come again? That was heavily investigated in a thorough investigation done by the feds. How do you know that? Do you have a relationship with the U.S. Attorney's Office over there, Hank Brennan? Is it inappropriate? How in the world would you know what was heavily investigated in their thorough investigation and absolutely no charges are going to come from it? I don't think you know any of those things to be true. I think you're using inferences in your argument, which is something you're allowed to do as a lawyer. But the problem is you would never let the defense say that. Like, if the defense wanted to argue that in front of the jury, Higgins was heavily investigated by the feds. Now, why would they be investigating another cop, an ATF agent? Horrible argument. Should not have made it. Yanetti comes and hammers it later. I put in my notes, woof, how can you possibly make that argument? You don't know what the feds did. Bad argument. Maybe use some other language I'm not going to repeat here. But I hate the way Hank Brennan has handled everything around the federal investigation, in my opinion.
There was no evidence of third-party culprit. There were no indictments. And so Although we don't know the parameters of the federal investigation, and we can only guess as to.
How can you just told us what the parameters were. You just told us what the parameters were, and then you told us we don't know what the parameters were.
But we know from what we did receive and review, it was thorough. And if there was third-party culprit evidence, we would expect that there would be a basis for it. It's not an entitlement to simply bring it in under vote.
All right, so let's jump now to what Yanetti had to say about this. Well, I thought I had Yanetti here. That's not great. All right, we got our first problem here. When does Yanetti come up? Here we go.
Federal investigation.
People.
First of all, Your Honor, speaking about the federal investigation, when you were not a part of it, and talking about why a federal grand jury was convened, what they were investigating, what they found or didn't found, is complete speculation. Should not be a part of this argument. We don't know. It didn't prove anything. It's not as though they came up with a statement exonerating anyone. So that should not be considered by the court.
100%. They did nothing of the sort. And frankly, the way Hank Brennan has shaped the conversation, it seems like it was good for the defense and bad for the Commonwealth, if anything, the federal investigation. So great job by Yanetti again. Siobhan said, Civil Psych asked, do Florida trials only allow juror questions in civil cases? Because my juror questions were great. It's great to get the truth. So most cases in Florida allow juror questions. Certain judges may not. But if lawyers really push for them, every case we've ever wanted juror questions, we've gotten juror questions. And most judges are cool with it, criminal and civil. All right. Then we get to the motion for the unsolved production records. I think Judge Cannone is going to grant that and going to give the Commonwealth all those records. The jury impoundment and Yanetti's phone are the next two things. We're going to do Yanetti's phone up first. And Brennan basically repeats his argument, says he doesn't want all the communications, just what's limited to those 3 days, and talking about liability and what the discussions were on culpability and what she told Yanetti, what Yanetti told her. Then Alessi gets up and says, he makes this whole argument about the overarching problem with this, how people should be concerned about this, how in the interest of justice, you should never let this stuff out. They've had these statements for months. I actually thought one of the best arguments he made was they've had these statements for 9+ months when they were originally made, and then they were repeated, and they did nothing about it until the eve of trial, and courts frown upon making very serious requests that could change everything about the trial on the eve of trial, which to me was an argument for Alessi saying, I know I might lose on the law, that legally, theoretically speaking, if we're making these arguments, she did waive, and technically Judge Cannone could turn over like those specific statements potentially. But the best argument is, Judge, in the interest of justice, this is bad. We can't do this in front of the right before the trial, because that's going to create a big delay, all this stuff we have to deal with that they've had plenty of time to make this decision, and therefore they've waived the opportunity to do so. We're going to listen to a little bit of his legal argument because it was really good. He does get cut off eventually, which this is one of those situations where it's like the judge can cut you off and tell you to shut up, and you love it, and you sit down and shut up with a smile on your face if it means you're winning, because you don't need to argue anymore if you're winning. So let's take a listen here to a little bit of the argument, and then what Judge Cannone's decision is here on whether or not Yanetti's communications with Karen Reed will be turned over from the days January 29th to February 2nd.
Discussion. The docuseries regards the same events that have been extant in the first two that have been extant for 9 months and 5 months. The depth of this attempted intrusion by the Commonwealth should disturb and unsettle every citizen of this Commonwealth, because they're either actual or potential clients of lawyers, and it should unsettle every criminal defense attorney in this Commonwealth, and I would dare to say it probably does. As we know.
So while I agree with him, with 100% certainty I agree with him, I would also venture to guess the majority of criminal defense attorneys in their jurisdiction and around the country would tell their client to keep their mouth shut pre-trial as a criminal defendant and not go say things publicly. That would be the most common advice I think that would be given to criminal defendants. And if you allow interviews and you sit there and allow it and allow her to say, me and David spoke about this, you know that you're opening up potential risks. So that's the only pushback I would have. And I think Alessi would agree with me, but I don't know.
Texts, emails, and written communications, exactly what the Commonwealth is seeking here, between an attorney and their client, are canonical examples of privileged material. So what is at stake in this motion? What is at stake is the sacrosanct attorney-client privilege. In Upjohn versus United States, the really bedrock attorney-client case from the U.S. Supreme Court, it established that dating at least from the age of Shakespeare, the attorney-client privilege is the oldest privilege for confidential communications known to the common law. And this Commonwealth has identified that it is one of the most important, and it's been recognized in the Commonwealth as early as 1831. And in the context of criminal circumstances, the privilege has constitutional dimensions, as well as it affects the interests of justice analysis that is documented in the Commonwealth v. Golden case 395 Mass at 502. And it bears underscoring the basis and the depth of the intrusion is a quote from the very case and the only case that the Commonwealth cites in its motion. It cites one case in its motion for all of its propositions, just one. Matter of a John Doe grand jury investigation, 408 Mass 480. In the case at 485 states, as we have indicated, extraordinarily high value must be placed on the right of every citizen to obtain the thoughtful advice of a fully informed attorney concerning legal matters. A rule that would permit or require an attorney to disclose information given to him or her by a client in confidence, even though such disclosure might be limited to the period after the client's death, would in many instances, we fear, so deter the client from telling all as to seriously impair the attorney's ability to function effectively. We think that
So, and I hear people complaining about the audio. I'll give you a second to adjust if you need to. I will try to just play a big chunk of the video, not interrupt it a ton if the audio is bothering you. I apologize. Nothing else I can do about it because of the court audio. But in this scenario, you can hear him making his argument. It's very different than when he stuck to the law and the methodology and what they're not proving. He's not talking about the fact that Karen Reed didn't waive it. He's not talking about the fact that this happened unintentionally. He's not making any of those arguments, right? Because I don't think those are winning arguments. He's pounding the table. It's like you have the facts, argue the facts. You have the law, argue the law. If you have neither, pound the table. At this point, he's pounding the table saying, in the interest of justice, we just cannot do this. It's not right. We can't turn over these communications. That's the argument that he's making. And frankly, it's his only and best argument, in my opinion. And I thought the judge would allow a very limited turning over of text messages that said, if I would have clipped him, did he throw up? And Yanetti saying you could have culpability. Like those three text messages, if they exist. I don't even know if they exist, right? And I think it would have been a huge, huge problem to allow that with a criminal defense attorney. And if the judge would have done that, I would have been like, wow, I don't think a lot of judges would have done that. But in this case, are you surprised that he did that? The defense may have given them the opportunity by going on national TV and having her say, I was talking with David and this is what we talked about. Then potentially I think she could, within her discretion, find a way to let those 2 or 3 text messages out. Definitely not all the communications over 3 days. Never going to happen where it's, that broad. But instead, she made a much better decision in the interest of justice, in my opinion. And we've got to give kudos when kudos are fair.
The potential is inconsistent with the traditional value our society has assigned. Here's a key point. In the interests of justice, and that's the rooting of the interest of justice analysis, to the right to counsel and to an effective attorney-client relationship. Therefore, except where mandated by constitutional considerations, and it cites the Commonwealth v. Goldman, Super 395 Mass at 502, which are not a factor in this case, nor are they a factor in not a factor in that case, we conclude that the attorney-client privilege should not yield either before or after the client's death to society's interest as legitimate as we recognize that interest in obtaining every man's evidence. So the case the Commonwealth cites supports the protection of the attorney-client privilege. With that law jurisprudential predicate in mind, I now turn to the statements at issue here and their import to that analysis.
You know what, Mr. Alessi, I'm going to stop you. I understand the Commonwealth's argument regarding waiver. I understand that the request is now routine, but I'm not going to give you this information, Mr. Brennan. I don't think it's appropriate for me to have so the motions tonight.
So she says, I understand your argument. I'm going to stop you, Alessi. Alessi was like, what? She's like, I understand your argument about waiver, which to me means I think she did waive. And I understand your argument about that. You're narrowly tailoring it because you have to do that if you're going to argue something like this. I would argue, whatever. It's narrowly tailored, but you can't have this. I don't even think I should have it, she says, as the judge. Kudos. Great decision in the interest of justice, especially because I think legally, if she wanted to, she could have turned over at least some attorney-client privilege communication. It's just how I read the case law and the rules. That's what I could have. I think there was a legal argument. I think it would have been wrong. I think it's bad. I don't think we ever want to do it. But I also don't want my clients going on national TV and saying what we spoke about. I don't even want them saying it in a room with one other person, right? Let alone national TV. But that was a great job. And I think this is a great comment. Poor Alessi probably spent 12 hours preparing. Well, guess what? Most lawyers, I'm not going to speak for any other lawyer. I'll kind of speak for myself. But generally speaking, when I talk to other lawyers, I have a lot of lawyers in my firm. I've worked with different lawyers in different places. Most of the time, when you win a huge argument like this and the judge is with you and she shuts you up and tells you to sit down and you win, you don't really care about how much you prepared because you won. You'd much rather that than prepare for 12 hours, argue for 45 minutes and lose, right? That's the big deal. Is I'd much rather them tell me to shut up and sit down and I win. I don't really care. It's kind of like we talk to clients, like we want results. I don't care if I look good. I don't care if everybody says I'm the best afterwards. I don't care if the defense says they're scared of me. I'm talking about in civil cases. I don't care about any of that. I want the result. We work and fight for the result. And in criminal cases, a lot of times they pay for the result. And that is the result Karen Reed and her team wanted. That's the one they got. Joe Mendoza, hello from now a potential Hillsborough County juror. I had not gotten any jury duty letters in DC, but maybe I will now that I have moved to Tampa. Wouldn't that be funny if I saw you, Joe? Now I would think you were, I think this is Superman Henry Cavill in your picture here. So if I see Henry Cavill in any venire that I am about to try a case in Tampa, then maybe I'll be able to point you out and say hello. Okay, then we get to they go talk in camera for a second. They talk about jury questionnaires. They talk about the ARCA witnesses. Hank Brennan still has grave concern, but we'll still see if they provide more information on that. And we have the motion to dismiss here. It's already past an hour, so we are not going to read the entirety of the motion to dismiss. But just so people can kind of see what we're working with, I will read. And thank you for Ashley for sending this to me. I will read just here the first page. On June 9th, 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of M in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of a personal injury and death following the death of her boyfriend, John O'Keefe, on January 29th, 2022. The Commonwealth's theory of the case is that the defendant, while intoxicated, struck and killed O'Keefe while operating her vehicle in reverse and left the scene. Trial on the matter began April of 2024 and concluded on July 1st, 24 with a mistrial. The matter is set for trial in April of 2025. Ahead of the retrial, the defendant has filed a motion to dismiss for extraordinary government misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct. I would agree with you. I would agree with you, Judge Cannone. That is what it should be limited to. In all but the worst cases, the appropriate remedy is at best a new trial, such as the one that is scheduled to begin soon. Because the claimed violations here do not rise to a level that would justify the most draconian sanction of dismissal, and because the defendant's constitutional rights can be fully protected in the coming trial, her motion to dismiss is denied. This is, again, when we talk about did Judge Cannone have the legal grounds to use her discretion and come up with something with the text messages? Yes, she also had the legal grounds here to draft this exact answer that, with all these problems they brought up, even if they are legitimate, the best remedy, the best way we fix it for all the crap that happened in the first trial and all the crap that's happened pre-trial, I, as the judge, have fixed all of those problems. And the best remedy is trial number 2, which is what we're going to do. That's how Judge Cannone reviewed this motion to dismiss. Let me see if there's just like so here's a big just discussion section. Let's see if there's just like a summary at the end or a conclusion. Yeah, it's 39 pages. I don't have time to do it now. I guess it's only 27 pages. No, and it just says for the foregoing reasons. There's no like conclusion, huh? All right, 27 pages. Now we only actually have to read 26 pages, actually 25, because here's the for the foregoing, it's denied. So we will definitely do a video on this. If you guys want it, let me know. Put motion to dismiss in the chat, and I will do a video on this at some point, reading the discussion, seeing why Judge Cannone came down the way that she did. Also hit the like button on this video. Let's get this video to over 10,000 likes. And if we do, I will go through this entire motion to dismiss with all of you so we can see exactly what she took into account. What did she mention? What did she talk about with the investigation? What did she talk about with the videos? What did she talk about with any of the witnesses? What the cops did or didn't do? Potentially, from my perspective, it would be a very interesting read. I haven't had an opportunity to read it. It came out during the time we were filming this video. So if you guys are interested in it, again, you know how to let me know, and make sure you like this video. That's all we got for this one. Okay. So we were able to get through a lot of it, discuss the big picture items. We got the overall view of why the motion to dismiss was denied. I feel like we got through a lot, right? I feel like a successful day, successful video. I love checking things off my list. I love accomplishing goals as we go throughout the day. So thank you for being here with me to do that. And if you guys haven't subscribed, make sure you subscribe as well. We're really trying to get to 500K. If you know anybody that's not subscribed, even if they don't watch, tell them to go over there and hit that subscribe button to help us get there, because we're slowly working our way to 500,000 subscribers, which is incredibly wild on YouTube. So I appreciate you guys so much for joining me, for hanging out with me, for being here through some tough chats in this case and the Lively and Baldoni case. But we're going to keep on keeping on, keep doing what we're doing, seeing cases, breaking them down the way we do. I enjoy it. I think you guys enjoy it for the most part. So we're going to keep doing it because that's, bring some joy to life. That's what we like. That's what we're about. And of course, we're big fans of justice. I appreciate you guys so much. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know. So we're sticking around for an encore here real quick because Bodie asked a question I meant to say. I made myself a mental note. I was like, I want to say this. So Bodie said, Peter, if Karen Reed told the press about the conversation with her lawyer, why does the prosecution need permission to use that? I wanted to bring this up, Bodie. So thank you so much for asking it. You guys are literally the best. When I say you add so much to this channel, I truly mean it. They can absolutely use these statements. If they want to put these statements in through Voss or, playing part of the documentary or whatever, there's different ways to get Karen Reed statements in. These statements are absolutely, in my opinion, admissible by statements of the party opponent, statements against interest, statements of the defendant, that they can come in. Now, there's going to be context. What can the defense put in? Does the Commonwealth really want Karen Reed's entire interview put out there where she gets to tell her story without being cross-examined? What's the rule of completion going to look like? So we've got to talk about exactly what's going to come out. But just because they can't get the actual text messages, emails, written communication between lawyer and client doesn't mean that these statements are inadmissible. It was specifically denied that she's not going to make Yanetti or Karen Reed turn or the stuff they already have. They're not going to get the actual documents and text messages and communication between the lawyer and the client. That's what's sacred. What was said publicly is admissible and fair game, and the Commonwealth can use it. Lally could have used it last trial, didn't. The statements that were made. So thank you so much, Bodie, for bringing that up. You guys are truly the best. Casey Cat, what's the likelihood of Colin Albert is soon rehomed like Chloe? Good one. All right, that's all we got. I don't know if I should run the outro again. John's already off, so I guess we'll just say peace out.